Hello, this is Alex Layton. I'm a barrister practicing in London at 20 Essex Street, and this is the first of two talks I'm going to be giving for the European Civil Observatory on Regulation 44 of 2001, usually known as the Brussels I regulation. The Brussels I regulation is the latest manifestation of a code of rules that dates back till 1968, when the Brussels Convention was originally concluded between the then 6 members of the European Community. It contains provisions on jurisdiction, and it contains provisions on recognition and enforcement. In this talk, I am going to be giving a little introduction to the regulation, and then I'm going to be discussing the jurisdiction provisions. In the next talk, which will follow, I will deal with the recognition and enforcement provisions, and I will discuss the proposals which are currently before the institutions of the European Union for a revision of the Brussels I regulation, sometimes called a recast. Starting then with the Brussels I regulation, as I say, it has grown over a number of years. There is a parallel regime involving a number of European countries outside the European Union, namely Norway, Iceland, and importantly Switzerland, called the Lugano Convention. And what I say about the Brussels I regulation applies probably equally to the Lugano Convention, but there are some points of difference. I won't be discussing the Lugano Convention in any greater detail. There are a number of features of this. Right from the beginning, the Court of Justice has had power to issue preliminary rulings under the reference system and has delivered about 150, a little over 150 decisions over the years on the interpretation of what I call the Brussels-Lugano regime. The most important characteristic of those decisions is, in common with other provisions of European law, that many of the terms, not all of them, but many of the terms in the Brussels I regulation are to be given an autonomous interpretation. That is to say, they are not to be taken as a reference back to the equivalent provisions in national law. Now, what I propose to do is to go through the regulation more or less following the order of the regulation itself, and if you have a copy of the regulation handy, it would be helpful for you to have it in front of you as you listen to this talk, because I'm not going to be going through each of the provisions in detail while reading out their text. The first section defines the scope of the Brussels I regulation, which is that it covers civil and commercial matters. Now, there's an autonomous interpretation of civil and commercial matters. That phrase may mean different things in different legal systems, but in the context of the Brussels regulation, it means private law relationships between parties. There are some specific exclusions I'll come to in a moment, but the biggest exclusion is areas where public authorities are exercising their public law powers. Those are not civil and commercial matters for the purposes of the Brussels I regulation. There are then, as I say, a number of specific exclusions. Insolvency, that of course is the subject of a separate regulation, the insolvency regulation, and there may be difficulties in some cases of working out the respective borderline between the two, but it's fairly clear that there is not intended to be an overlap between them. Arbitration is, in practical terms, a very important exception, and the scope of that exception has been the subject of a number of cases before the European Court. There's a famous decision of the European Court called West Tankers a couple of years ago, and one of the key points to emerge from that is that a preliminary issue on a subject excluded from the scope of the Convention may still fall within the jurisdiction provisions of the Convention because the substance of the underlying case falls within that scope. There is then Chapter 2 of the regulation, which covers the jurisdictional provisions, and that's what this talk is going to be principally about. The starting point is the general rule in Article 2 that a defendant domiciled in a member state shall be sued in the courts of that state. Now, there are a couple of things to notice about that. First of them, the use of the word shall be sued. The rule has been interpreted as meaning that where the court has jurisdiction under Article 2, it must exercise it, except in situations foreseen by the regulation itself. There's no scope for the common law doctrine of forum non conveniens, enabling courts with jurisdiction not to exercise it, but to stay their proceedings in favour of the courts of another a court which has competent jurisdiction of another country. That is not permissible in the context of the Brussels regulation. Notice that I said defendant domiciled in a member state. Much of the methodology of the jurisdiction provisions of the regulation turns on these concepts of domicile. And there are two different approaches depending on whether one is talking about natural persons or legal or artificial persons or associations of persons. The case of natural persons is governed by Article 59 and refers the question of whether a person is domiciled in a given member state to the law of that member state, so that is a reference back to the national law. The case of legal persons, however, is different because Article 60 provides a broad, uniform definition of domicile for the purpose of companies, namely either where they have their principal place of business or where they have their statutory seat or their registered office. And so it's a very broad definition. And it's important to note that both under natural persons and in the case of companies, it's possible for a person to have more than one domicile. All that is required is that the person be domiciled under those rules in a member state. Now, as I say, Article 2 gives the general jurisdiction to the courts of the member state where the defendant is domiciled. And there are then a number of other rules that provide alternative bases for jurisdiction. And there are a couple of exceptions, and we'll come back to the exceptions. The alternative rules are importantly included in Article 5, which has a number of sub-articles. Article 5.1 relates to matters relating to a contract. And this, in practical terms, is one of the most important articles in the convention, in the regulation. The rule here is that a defendant domiciled in one contracting state may, in another contracting state, be sued in the courts for the place of performance of the obligation in question. Now, what is the place of performance of the obligation in question? Under the earlier rules, that question was to be determined by the law applicable to the contract, determined by the choice of law rules which applied in the individual member states before they were unified. And of course, they're still not completely unified. They're mostly unified in the Rome I regulation now. But now there is a uniform definition in respect of what is going to be the very largest share of these cases, that is to say, cases involving the sale of goods and the provision of services. In those cases, the place of performance of the obligation in question is the place where the goods are or should have been delivered, and in the case of services, where the services are or should have been performed. Now, it's important to notice that it is not only the obligation to deliver the goods or to perform the services which is deemed to take place in that location, but also other obligations, notably the obligation to make payment. Under the older rules, you had to examine where the payment obligation was to be performed in order to decide whether or not there was an Article 5.1 jurisdiction. Now, for the most part, you don't have to do that. You just look to see where was the place of delivery of the goods or the provision of services. In contracts which don't involve the sale of goods or provision of services, you still have the old rule, namely you look to see where the place of performance was of the obligation upon which the claimant bases his claim. Another of the important rules, the other centrally important rule in Article 5, is the rule relating to tort, or tort-delict or quasi-delict. Here, the rule is that a defendant domiciled in one member state may be sued in another member state in the place where the harmful event occurred. Since the very early days of the Brussels Convention, it has been decided and well understood that gives the claimant an option. He can either sue in the place where the wrongful conduct occurred, the wrongful act or the wrongful omission, or he can sue in the place where the damage ensued, if that is different. So the place where the harmful event occurred has this double meaning at the claimant's option. But if the claimant sues in the place where the damage occurred, firstly, that must be the direct damage, not some consequential or more remote, usually financial loss. And secondly, he can only recover damages for or whatever relief he's seeking in respect of the damage suffered in that member state. If damage is suffered in more than one member state, he can't concentrate his claim in respect of all that damage under Article 5.3 in any one of those member states. Except that there is a qualification on that as a result of a recent decision of the European Court in a case called e-date advertising, which says that in claims for damage caused by publication over the internet, not only the place where the defendant is established, but also the place where they have their centre of operations have jurisdiction. Article 5 also contains other rules of special jurisdiction relating, for example, to claims for maintenance, which is now very largely redundant as a result of other legislation in that field. Claims relating to trust instruments, claims relating to claims for civil damages based in criminal proceedings. They are also dealt with under this provision, some maritime claims, and importantly, claims arising out of the activities of a branch, agency or other establishment of a defendant domiciled in another member state can be brought in the state where the branch, agency or other establishment is operating. There are then some rules that allow jurisdiction to be based on a procedural basis. Article 6 includes these. Let me give some examples, the important ones. Firstly, as a co-defendant, where a defendant is domiciled in a member state, he may be sued as a co-defendant in the court where any of the other defendants to the proceedings is domiciled. Note that a co-defendant cannot be joined on the basis of a principal defendant being brought before a court other than a court of the principal defendant's domicile. So if the first defendant is being sued under Article 5.3, for example, in a tort case, a co-defendant cannot be brought in under Article 6.1. There needs to be an independent basis for jurisdiction against the co-defendant in that situation. Another example is that a third party may be joined into the proceedings, be brought into the same court as the defendant is being sued in the main proceedings, Article 6.2. And Article 6.3 deals with jurisdiction in respect of a counterclaim, where the defendant to the counterclaim is the person who brought the proceedings and court in the first place. There are then three separate sections of Chapter 2 dealing with special types of cases, cases involving insurance, cases involving consumers, and cases involving individual contracts of employment. All three sections proceed on the basis that one category of party is in a weaker social or economic position, that is to say the consumer, as compared with the supplier, the insured beneficiary or policyholder under an insurance arrangement as compared with the insurer, and the employee under the individual contract of employment as compared with the employer. In each of these cases, that supposedly weaker party has got a wider range of choice of jurisdiction than they do under the general rules, and in particular, they are enabled to bring proceedings in the courts of their own domicile. They could also bring proceedings in the courts of the defendant's domicile and one or two other specific rules, but the rules are more generous to plaintiffs in that situation. And significantly, these rules are mandatory to the exclusion of most of the other rules of the regulation, but they also deal with the power of the parties to contract out of these special schemes of rules. And the opportunities to contract out of those by agreeing a jurisdiction agreement are much more limited. There are some limited circumstances, for example, where the agreement is made after the dispute has arisen, or where it widens the choice available to the social or economically weaker party, and in insurance cases where there are large risks involved, much more in the commercial field or in the international transport field. Those are areas where the parties can contract out of the otherwise mandatory rules in these sections. But they have a significant practical importance. We come then to Article 22, which has one of the most rigorous systems in the regulations regime of rules, and it relates to exclusive jurisdiction. And this is one of two cases where the rule applies even if the defendant is not domiciled in a member state. In this case, these rules for exclusive jurisdiction apply wherever the defendant is domiciled, and they're based on the legislator's view that there is a particularly strong and close connecting factor between the subject matter of the case and the court being given power to hear it. And the first of them relates to rights in rem in immovable property, and most, not all, tenancies of immovable property. Exclusive jurisdiction is given to the courts for the place where the property is situated. Other rules within Article 22 provide for exclusive jurisdiction in respect of the internal or constitutional workings of companies or associations of natural or legal persons, relate to claims concerning the validity of patents, into entries in public registers, and into proceedings concerning the enforcement of judgments. And by enforcement, they mean proceedings involving the actual execution of the judgment, the means by which force is used or other power is used of the state to extract payment from the judgment debtor. In these cases, as I say, exclusive jurisdiction applies. No other court is entitled to hear the proceedings, and any other court must dismiss its proceedings for reasons we'll come to in due course. The second example where the regulation provides a rule irrespective of whether the defendant is domiciled in a member state is Article 23, which relates to jurisdiction agreements. In this case, a court can have power conferred on it by the agreement of the parties to hear a case, provided certain conditions are satisfied. And the first of them is that one of the parties must be domiciled in a member state. It doesn't have to be the defendant. Of course, at the time when the agreement is entered into, it's not necessarily clear who's going to be the claimant and who's going to be the defendant. And the rule, therefore, is that it's provided that one of the parties is domiciled in a member state, this article operates. The parties in that situation can confer on a court or the courts of a member state jurisdiction to hear any disputes relating to a particular legal relationship, and the effect is not only to confer jurisdiction on that court, but also to derogate from the jurisdiction that would otherwise be available in other courts. That is to say, it is an exclusive effect gives effect to these agreements in an exclusionary way unless the parties have otherwise agreed. That is to say, the parties are free to enter into a non-exclusive jurisdiction that only has the conferring power, what's called prorogation, but unless they do so, then the clause or the agreement will be taken to have not only that conferring power, but also a derogating power. It will deprive other courts of jurisdiction. There are a number of requirements of form for one of these jurisdiction agreements to be effective, and these are very important in practice. They must satisfy one of three different criteria. The first of them is they must be in writing or evidenced in writing. And there is a degree of case law concerning what that means as a matter of autonomous interpretation of the regulation. It means, for example, that there may be a post-contractual incorporation of standard terms which can constitute a sufficient form of writing or evidence in writing. The second of them is that, as an alternative, the agreement can be in a form which the parties have established between themselves. And the third of them is, in the case of international trade or commerce, the agreement can be in a form which complies with the usages of that particular trade or commerce and which was or ought to have been known to the parties. Those requirements of form are there in order that the court can be satisfied that there is a real consensus between the parties as to the court which is to have jurisdiction, and that the consensus can be clearly and precisely demonstrated. There are a lot more detailed provisions of case law relating to jurisdiction agreements, and again, this is an important field and one that I can't go into in sufficient detail in this talk, unfortunately. Jurisdiction can also be conferred by entering an appearance. A defendant can confer jurisdiction on a court which wouldn't otherwise have it if he's been sued in error by the claimant there, and he enters an appearance without disputing the jurisdiction. The purpose of that rule is to overcome the difficulty that would otherwise occur if the case proceeds without the matter having been ventilated before the court. What amounts to an appearance may vary from system to system, but what is clear is that provided the jurisdiction is disputed, at any time up to the time when the defendant must first identify what his defence to the case is, then that is such as to remove what would otherwise be the automatic conferral of jurisdiction under Article 24. The rule must be subject. This is subject to Article 22 exclusive jurisdiction. You can't confer jurisdiction on a court which doesn't have it in one of the subject matters where there's exclusive jurisdiction under Article 22. There are then two articles, 25 and 26, which require the courts to examine their jurisdiction of their own motion in two cases. Firstly, to ensure that the case is not one over which the courts of another member state have exclusive jurisdiction under Article 22. And secondly, in cases where the defendant does not enter an appearance and the court is being asked to enter a default judgment against the defendant, the court must satisfy itself that it has jurisdiction under the provisions of the regulation before it permits a default judgment to be entered. There's then an important set of rules in Articles 27 to 30 to deal with the situation where parallel proceedings have been started in more than one member state. The first group of rules relates to a case where the same cause of action is in issue between the same parties in more than one member state, what one might call the strict case of lis pendens. And in this situation, there is a very rigorous and rigid rule that any courts other than the court first sees must stay or dismiss their proceedings so that the case can be pursued in the court first sees, that rule of priority. The situation there is that the identity of parties is clear enough, but what constitutes the same cause of action is a fairly liberal rule, so that, for example, if A sues B in one member state and B sues A in another member state for a declaration that B is not liable to A, those constitute the same cause of action. English encapsulates the phrase more than some other languages do and is apt to mislead. The European Court gave a decision on this where it emphasises the use of the French language text, where those words are la même cause et la même cause et le même objet. In that situation, there needs to be both the same objective of the proceedings and the same intended outcome, if that will constitute the same course of action. The second group of rules relate to where there are related proceedings in more than one member state. And in this case, the cases need not involve the same parties, they need not involve the same course of action, they need merely to be related. And there's a definition of what related means. It means that the proceedings must be so closely connected that it is expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from separate proceedings. In both cases, there is now a uniform definition of what constitutes seizing. How do you know which court is a court first seized? Different member states have different procedures for starting civil proceedings. Now, there is now a uniform rule which basically amounts to saying that when the court's process is issued in court, that is the moment when it is seized, unless the procedure requires that it be served before it is brought to the court's attention, in which case the moment of service is the moment of seizing. The final topic I'm going to deal with under the jurisdiction in the Brussels regulation, it concerns what, as English lawyers, we call interim relief, is provisional, including protective measures. And in this case, I am going to read the article of the regulation. It says this: application may be made to the courts of a member state for such provisional, including protective measures as may be available under the law of that state, even if under this regulation, the courts of another member state have jurisdiction as to the substance of the matter. Now, there are a number of points there to be noticed. The first point is that recourse may be had to this article only when the court to which the application is made is not a court with jurisdiction over the substance of the case. Now, it may not have jurisdiction because there's no rule under the regulation that gives it jurisdiction. It may lack jurisdiction because the subject matter scope of the principal underlying claim may be outside the scope of the Brussels I regulation, as, for example, if it is subject to an arbitration agreement. Or it may be because the courts of some other member state are the first seized, and this court to which application is made for provisional measures is not the one in which the underlying dispute will be resolved. Any such proceedings must have a real connecting link with the member state of the courts to which the application is made, and the measures must contain provisions that guarantee their provisional nature, such, for example, as the giving of security. Subject to those things, applications can be made to the courts of a member state under that state's own jurisdictional rules, even the rules which would not apply to the underlying claim under the law of the member state, such, for example, as the rules of exorbitant jurisdiction, which are excluded. I didn't mention this earlier, but this is an exclusive system, excludes the rules of national law that would otherwise apply. So, for example, under the French Code Civil, persons of French nationality have access to French courts. They have access to French courts for interim relief, even though they would not, under the Brussels regulation, have the benefit of that rule to enable them to get jurisdiction over the substance of the case. and the measures that are available are not autonomous or uniform European measures. They're only such measures as are available under the law of that member state. Well, there we are. That's the jurisdictional rules. We'll see in the next lecture how they interlock with the provisions relating to recognition and enforcement. And then I will, as I say in the next lecture, also deal briefly with the proposals for reform of the Brussels I regulation. Thank you very much.